Alex here with a legal nuts and bolts case on anticipating the response. So anytime you're asking the court to do something, and basically whatever it is, you're either curtailing your ex's parental rights or having them ordered to do something that they don't want to do, you have to think up all of the things that they're going to either um, give as an excuse or all of the possible lies that they might use way in advance, not just before you end up in court, but before you even start preparing your motion. You have to start doing this because you're going to want to tailor your motion. You're going to want to tailor this from the beginning all the way to the end, which includes the motion and the exhibits that go to it, in a way that you've either covered all of the possible excuses that they could use or expose whatever lies they might bring up. So I guess the best way to do this is with examples, and since I've been in a high conflict child custody case, I have at least 3. I'm going to go ahead and use the biggest one, which I've already talked a lot about in my modification of physical custody video, because it sort of shows how you can chain this process along. When I had the issue that my son had 5 crowns and 2 extractions, my first thought was I'm going to need, well, not my first thought, there was a bunch of thoughts, but in the end I realized I needed to modify physical custody. And the first thing I thought is, if I accuse her of not brushing his teeth and causing him to have 5 crowns and 2 extractions, which is severe, what is she going to do? Well, first off, I thought she's going to lie and say that it was me too, that it was both of us, and that since the court couldn't pinpoint it to just her, the court couldn't modify physical custody, which is a totally valid defense. So if she's going to say that, then I need to figure out how to prove it was just, it was all hers. So the first thing I thought was, I need to get some kind of test or some kind of evidence. And that's when I found out from the dentist about the red coat testing. And once I thought of the red coat testing, I was like, well, that's great. Now I'm going to have some evidence as to, the fact that his teeth aren't being brushed, because that's what that test reveals. It reveals specifically that there's no toothbrushing going on. I was thinking, well, she's going to say that I am doing the test right at the end of my visitation schedule. And again, that's an effective way to point the finger at me. So I thought I'm going to have to actually do these tests right when I pick them up. And at that point, I thought she's going to say I'm lying. So I'll tell the court I did these tests when I picked him up, and here's the tests, and her defense will be, he's lying, that's not when he did it. So my reaction to that would be, I'm going to have at least a few of these done in the dentist's office by the dentist. And that's exactly what I did. And at that point, I thought to myself, now if she claims I'm lying, I have the witnesses, the dental hygienist and the dentist. And exactly at corner, she didn't want to admit something so severe, so egregious. And so she was forced to lie in court. And when she did, I brought the hygienist in and the dentist in, and she was basically destroyed and on the stand. And the court completely believed the dentist and the hygienist and modified custody. So that's sort of how you can navigate a strategy from the very beginning, by anticipating what your opponent is going to say. Too many people just don't even think about what their ex is going to do and just go into court and just wing it, and it does not work. You need to think about this all the way from the beginning. Another example I'll give you is when I had her held in contempt of court. She was having this huge problem of giving me his backpack and his school homework. And so he would end up going to school without his homework. He couldn't do it. He couldn't turn it in because I didn't get it from her. And so when she made them, I guess you could call it a mistake. I think it was on purpose. She made it like 3 or 4 times, and I kept track of each time. And then I finally told myself, I'm going to need at least one time, before I try to order to show cause her, I'm going to need at least one time where I can show the court that it's not just an accident, that it's on purpose. So the very last time that she did it, I told her that I was planning on bringing this to the court's attention and to find a way to get me that homework. In other words, you didn't bring it when you were supposed to, but here's a chance for you to make up for that mistake. You could bring it to my work and leave it at the front desk. You could take it to the school the next day. She wouldn't even do that. She wouldn't even take it to the school the next day. There's all these things that I said she could do, and she didn't do any of them. And so then I filed a motion, and then she was held in contempt of court. I could have just gone into court and said, she's not doing what she's supposed to do. And then she could have gone and said, well, I'm sorry, I made some mistakes, and I'm going to try harder next time, Judge. And she might have got away with it. But because I showed the court that I had those emails at the end saying, you made a mistake, but here's how you can fix it. And he saw that not only did she make a mistake, but she wouldn't get the homework to me at my work or even take it to the school. It basically, as I said, I anticipated her excuse and I cut it off. The last example I'll give you guys is when, let's see, after I got primary physical custody, she was supposed to comply with these very specific notice periods to get to see our son. It basically required telling me, you know, a week or two in advance, I think it was 2 weeks, when she was going to come into town and exercise visitation. And she would come in the day before. She wouldn't give me any notice at all. She'd just say, hey, I'm here. I want to see him right now. Now, in my mind, I'm thinking I could totally say, no, you're not complying with the court's order. But I am a little concerned that you're going to paint me as some evil dad who won't let you see your kid, which is what she was doing the whole time. So I decided that the first time I would let her do what she did, and I would send a message saying, you're not supposed to do this. You're in violation of the order. I'm going to let you do it this time because you haven't seen him in she hadn't seen him in 4 months. But if you do it again, you're not going to get to see him. And of course, with a high conflict child custody ex, they're going to push those boundaries. So the second time she tried to do it, I said, nope, you can't see him. She tried again a third time. She tried again a fourth time. 2, 3, 4 times she was deprived of visitation because she wanted to paint this narrative that I was this evil person that wouldn't let her see her kids. Well, that might have worked. It shouldn't have worked. A good judge should ignore that. But it might have worked if I didn't have that first example. And so that's why I went ahead. I thought of what she's trying to do and how I'm going to cut that off. And I executed that plan. And ultimately, whatever, she did get an attorney later, but she never brought that up because probably the attorney was like, well, he's just going to say that he let you get away with it the first time. So the whole thing about me being a bad person and not letting you see your kid isn't going to fly, where I have an example of me doing exactly that, even though you violated the court's order. So again, when you're going through this process, you need to figure out what you're going to go and do through the court system. And whatever it is that you're going to do, you need to figure out how your ex is going to respond to that. The excuses that they're going to come up with and the lies that they might use. And based on what you think they're going to say or do, tailor your actions to try to minimize those things, cut those things off, or as a last resort. This is the hardest thing to do, is expose them as a liar. But sometimes that's what you have to do. And then, of course, look at how I did it in my case. I used a dental hygienist and a dentist. Really good witnesses. If you have to do it with word versus word, you're just playing with dice. It doesn't always work. So if you have to do it, you have to do it, and just go ahead and try it. But whenever possible, try to, do what I did in those examples and take a few extra steps if you can to just make your case airtight. There's probably so many more examples I could come up with if I wanted to write a big long list, but that's not the purpose of this video. I'm just trying to get people in line with this principle. And of course, post things in the comments below if any of you have ever had a situation where you were going to ask something of the court and you proactively, ahead of time, before you even filed the motions, thought about how you were going to deal with those excuses and lies, and you executed a plan from beginning to end and it worked. Let people know, because it's encouraging for people here to see that it's not just me that figured out how to do these things. So with that, I'm going to go ahead and end this video.